Hi, good evening, madam and my fellow friends. My name is Nurzaiti Emilia binti Muhammad Zafrina, and this is all my group members. So today we are going to explain about asset ownership and enjoyment. So I will explain about the introduction. As we all know that land is alienated to an individual, which is land can be only one person and also can be various person in one land. Land also can become the alien land. A person that will become is a registered proprietor. Also, land was divided to three, which is right to airspace, right to underground land, and also right to support. This is all the right that include in the Act. So as word by Colbert versus Hill was say that the owner of a land is the owner of everything up to the sky and down to the center of the earth. So I'll pass to the next member to explain more about this topic.
Okay, hello everyone. My name is Muhammad Shaputra. I will further explain the law of and right of surface. Firstly, the right of airspace under Section 44 of the NLC, common law, whosoever owns the surface of the earth own also the entire airspace above it. Basically, in common law, it is used as a governing principle in determining the extent of one's ownership of those land. Section 44 of NLC further explains the right to enjoy one's land is not absolute, but an exclusive use and enjoyment of land. The right must be exercised in the consideration of the following limitation. Firstly, under subject to other provisions of the NLC 1965. Second, subject to any other written law, such as Civil Aviation Act of 1969. Next, that such enjoyment must be in a reasonable and necessary. Lastly, it must be lawful. Next slide. An example case of ownership of land is a case, Kelson against Imperial Tobacco, which held that an advertisement signboard erected by a dependent on their own property, which projected into the airspace above the plaintiff's shop, created a trespass. Even if the plaintiff has suffered no damages at all, he is still entitled to an injunction. Next, another example is Woolerton and Wilson against Richard Costain. Why is there a need to restrict the owner's right over his own land? Is an important question. The reason is that that there is a need to balance the right of an owner to enjoy the use of his land against the rights of the general public, which take advantage of all science now offers in the use of those airspace. Next, I pass to the next presenter.
Good evening to my respectful lecturer and dear classmates. I'm Sajid Muhammadiyah. Today I'm going to present the common law and right of the surface. So when we talk about the right to underground the land, the trespass to underground land is defined as adjudging a landowner by the means of the assets secured of this land and gain the entry to cave or goals and seem located it between the surface on the owner land. This will be outlines provisions regarding the mineral rights of the middle lease. The ownerships of the mineral and the mineral rights may be the distant from the surface land ownership, and it could be visited in the state of the granted separately. The NLC, the National Land Court, recognized the possibility of the granting the surface of the easements, allowing the certain rights to access or under the use the underground space between another person's property for specific purpose, such as laying electricity lines of the pipelines. Okay, NLC National Land Code might also contain the regulations of considering underground land to use in the context of the land and development and the planning and zoning, the regulations and the developments control may apply to the surface activities of the strategy. Next slide. The nature of right, a landowner has a right to support of his land in the natural state by the adjacent land and is entitled to have the land physically supported by his neighbor land, and thus a landowner has the responsibility not to withdraw the natural support that his land gives to the neighbor land. Next slide. In the case of Gun Sinting mining case, the right of the support was described as a negative right based on the law of torts. Adjoining landowner must be not cause the withdrawal of the natural support in the land. Next slide. Okay, before I'm explain the case law of the Karpan West Balakrishna, as a previous presenter is mentioned that under the sections 44 of NLC clause 1 and clause A is clearly provide that the landowner has executive use of the enjoyment of the land with the certain rights restrictions of the general principle which is not against the public. In that, according to that, in the case of the Karpan West Balakrishnas, in the fact of the case, the applicants had built a 4-story hotel stood in the lot of 26 and obtained the permissions of forgery in the lot 25 and undertaking to remove if the building letter on the 25. And the owner of the lot of 35 was built a hotel as a applicant, and he asked two applicants to remove the portraying windows, but the applicant was failed to do so. So when the defendant is when the plaintiff is bring the case to the court, the court held that the sections 44 clause 1 and clause A is clearly give that the owner of the land has the rights of to enjoy the exclusive rights which is provided under the sections of 44, and that is must be restricted under the rules and regulations of the law. With then the applicant is not as rights to enjoy the airspace. Is as right to enjoy the land, but it's not as right to enjoy the therefore the A head is omitted in the next.
Alright, so next I will present about the arising issue, which is the example scenario of trespass. So trespass actually is an unlawful entry by one person or an unlawful interference by one person with land in the possession of another. So for example, landowner has the right to sue for any interference, and trespass is actionable per se. So in the case Terra Damansara is an example of trespass, and actually liability is straight. So for the trespass, we don't need to prove any damages. On top of that, trespass actually is an actionable even if made under mistake, or if you believe the land was unoccupied or unrelated, or believe that it was his own. Alright, so next I will explain about the arising issue with and some cases. So actually this case is quite well known for the right of airspace. So the cases is named as Switzerland against Curtis Airport Corporation. First and foremost, in these cases, the court heard that airport cannot be erected in places where it's a normal operation would deprive someone from enjoying his property. It was also added that the aircraft need to be flown in a reasonable height. Hence, it will not deprive a person's right to enjoy land, then no action can be taken against the airport. So it means that the height of the aeroplane flight actually is not able to determine in these cases. So in Malaysia, this was recognized in our Civil Aviation Act 1969 under Section 19 Cross 1. It stated that no legal action can be taken an aircraft owner for flying over your land at a reasonable height. For example, this means that we are flying overhead normally is totally fine. There will be no problem if an airplane flies so low you could see the engines. A helicopter flew right next to your home. This section also says that if any damage is caused by the plane or object falling from the plane, The owner of the plant will be liability for this damage, and they need to responsibility in these cases. So if the damages was not caused, though they are not liability for these damages. So in these cases, actually, the plaintiff is not able to sue the defendant because the height of the aircraft is not able to determine. So I will explain about the restriction. So what is a restriction under National Land Code? So for example, a land owner may not use and extract metals and mineral from his land under Section 45 Clause 2A National Land Code. On top of that, subject to National Land Code and any other written law, for example, such as Section 92B and Section 92D, National Land Code and National Heritage Act 2005. Last but not least, restriction actually is a reasonable necessary to the lawful use and enjoyment of the land. So next I'll pass to Jyoti to explain about right of access. Thank you.
Okay, I will explain about the right of access. Right of access was be in section 44, clause 1, clause C, which is that provide the right of a landowner whose land is next to foreshore or any river or public place, the right to go there. And that also state there is no access that landowner may apply for the right of way to be created. Next. So the conclusion from all of this topic is, as we can see, is ownership is about the property or land. It must be valid and registered, and the person who are owner of the land must have the right to own it. They also have right to dispose their own land, and they also have a right to inherit it after he dates. So other side is possession. Possession is something that is someone hand or possession even if it's not his property, such as like someone else, which is a land tenant or taxpayer that not handling their own land, that handling another person of the land. That's all from us. Thank you.